There are a number of ways that a driving while intoxicated charge can begin in Texas. The one that most people think about is one where an officer or someone in law enforcement sees bad driving behavior or a wreck and then goes up to that vehicle. Understand, though, that officers don't have to see the bad driving behavior themselves to initiate a driving while intoxicated investigation. You might have a 911 caller or multiple 911 callers who call in and say a particular vehicle's driving down a particular roadway and is driving erratically. Officers might get behind that vehicle 2 minutes, 5 minutes, 10 minutes later and perhaps not see any bad driving behavior themselves and yet still be able to legally stop that vehicle based on the 911 calls. So that's the officers relying on third-party witnesses to initiate a stop. In both of those cases, they're developing reasonable suspicion for an investigation. It's the lowest level of proof, simply some suspicion that a crime has occurred. The third way for an officer to initiate an investigation is more a circumstantial case. Let's say an officer comes across a vehicle that stopped on the side of the highway at 2:15. Well, if it's already stopped, the officer is simply encountering, or what they would call a consensual encounter. They're going up to a vehicle that's already stopped, so there's no requirement for a showing of reasonable suspicion, and they're just trying to initiate contact with the driver or the person seated in that vehicle. So the third way officers can initiate an investigation is by simply encountering a vehicle that's already stopped.